Hello, my name is Jason Lazarus, founder of Synergy. With me is Kevin James, one of Synergy's senior lien resolution attorneys. Kevin is a military vet with service to our country in the Iraq War. He has deep expertise and knowledge in many areas of subrogation, having been on the other side with Rawlings for over half a decade. He's a licensed attorney and devotes his time these days to leading our team related to legal issues surrounding lien resolution, including Medicaid. Kevin, given the U.S. Supreme Court's ruling in Gallardo in 2022 and the Alborn precedents, what are the best tactics to employ in resolving Medicaid liens, and what should trial lawyers be aware of? Because I know this varies greatly from state to state, having handled many liens myself here in the state of Florida, which is different from most parts of the rest of the country.
Right. So that is correct. The Gallardo case really did change most people's understanding of what um, the entitlement to a Medicaid program would have in a third party liability situation. Prior to Gallardo, I mean, the battle really was Allborn. It's important to remember what Allborn stands for is it basically limits Medicaid's recovery to only that portion of the settlement that could be attributed to past medical expenses. What Gallardo did is that was how it was understood. What Gallardo did is expanded that definition of what a Medicaid plan could demand from a settlement. And it's no longer past medical expenses, it's medical expenses in general. Unfortunately, this does occasionally lead to absurd results because now a Medicaid program is allowed to recover out of settlement funds for payments it may never actually make, which is some types of a frustration. The other thing that Gallardo really did is the battle is now really in your state statute. So Gallardo was not a mandate that a Medicaid program could attach to future medical expenses. The local state statute has to have language supporting that. And we often see in various states that the state language of the statute limits Medicaid's claim to past medical expenses or payments that were actually made. So you want to be looking in your state statute for that kind of language. The other thing you want to be aware of is the Supreme Court was clear that if a member, there's not a reasonable probability that a beneficiary will remain on Medicaid, then Medicaid also is not allowed to attach to that portion of the funds that were future medical expenses. So if you have a client that's going to drop off of a Medicaid program or is no longer going to be on a Medicaid program for whatever reason that is, you definitely want to make that point that because there's no reasonable probability Medicaid will actually make future payments, they don't get the benefit of the portion of the settlement that was intended to compensate for future medicals as well. So the biggest difference between Allborn and Gallardo now is that it is medical expenses is the only thing that a Medicaid program is allowed to recover from, but it's medical expenses in general.
And so the key for trial lawyers is understanding that this varies greatly state to state and is dependent on what your state statute says. But remember, if the state statute, like here in Florida, does encompass future medical expenses, that opens the door to Medicaid trying to recover from all of the medical damages portion of the settlement. But, if you just want to save your firm time and money instead of trying to resolve Medicaid liens and be an expert in this area of the law, consider a partner with Synergy because you can outsource to the lien resolution experts like Kevin, who can make the right arguments and get to the best possible result for your client.